Attorney General.
Thank you very much, Mr. President, for allowing me the opportunity to speak on this bill. I will avoid using the long title, and I'd ask you to permit me to refer to it as the Miscellaneous Provisions Global Forum Bill 2024. Mr. President, the bill is before this Honourable House, having been passed in the other place on Friday last, the 13th of September, with amendments at the committee stage of the debate. And as in that other place, the Honourable Minister of Finance has comprehensively presented the essentials of the legislation. And I fully endorse that very comprehensive piloting and remarks of the Honourable Minister as to the importance of the bill and the need for its urgent passage in our national quest to be divested of the mantle of non-cooperating tax jurisdictions, a designation which has negative financial implications for our country. Given that comprehensive treatment, Mr. President, I will focus my attention mainly on those aspects of the bill which touch and concern the Registrar General's Department, in respect of which I am the line minister. Members will recall that very recently in this very august chamber, we passed the Miscellaneous Provisions Judicial and Legal Service Amendment Bill 2024, which, among other things, has made the Registrar General a Chief Legal Officer as head of the Registrar General's Department. And this is very important in the context of the important role and function which this bill is confirming for the Registrar General. Members of the House will be aware as well of the forthcoming visit of the peer review team of the Global Forum in just about 5 weeks' time. Mr. President, I mentioned in the other place that the Registrar General's Department has been assisted and continues to be assisted by the Global Facility. 3 members of the Global Facility were in Trinidad and Tobago last week. Their observations and contributions materially informed amendments to the bill, particularly those pertaining to legislation under the remit of the Registrar General, under my remit as Attorney General. And as I mentioned that, I pause to reflect on the usual strident remarks of Senator Mark when he speaks to loopholes. And let me assure Senator Mark that this is not so much about loopholes, but what I spoke recently about the scope for refinement. So, for instance, right now, as I speak, Mr. President, there is an ongoing workshop in the European Union AML Counter-Financing Terrorist Global Facility Workshop taking place right now. It started yesterday, it continues today, it continues tomorrow on the subject to turning financial intelligence into evidence. And I gave the opening remarks at that forum, at that workshop. And among the things that I said, Mr. President, in answer to and to address Mr. Senator Mark's stridency, I said this: while our current mechanisms for identifying suspicious activity and leveraging financial intelligence are robust, there is always scope for refinement. The evolving nature of financial crimes demands that we remain adaptive and forward-thinking. As the adage goes, learning is a lifelong journey. This training that is going to be taking place yesterday, today, and tomorrow serves as a platform for us not only to sharpen our expertise, but to also explore innovative strategies to enhance our efficiency and impact our financial investigations. This is not only about addressing deficiencies, but also about advancing and continuously refining our processes to ensure we remain at the forefront of combating financial crime. So that as we engage in our learning process and our refining process, and we look at our suite of legislation, we will, and I promise Senator Mark this, we will be coming back to this Senate, to this Parliament, with further amendments in that refinement process. It's really about, as I said in the House on this very debate, it's really about good governance. And in the remarks that I made yesterday, I also said this to the stakeholders who were present at that forum yesterday and today. Law enforcement agencies, the judiciary, policymakers, financial intelligence units, and regulatory bodies. Each entity plays an indispensable role in the broader system. Law enforcement serves as the first line of defense, investigating suspicious activity and gathering evidence. The judiciary ensures that justice is served, navigating and ensuring due process amidst the complexities of financial crimes. Policymakers, that is to say, those of us in government, inform and enable the legal framework that governs our efforts, and regulatory bodies create the oversight necessary to maintain compliance and integrity within the financial system. The strength of these individual contributions, I said, is magnified when they operate in concert. One of the things that we have been learning in that evolving framework, and I think all of us in Trinidad and Tobago will understand this when I utter it, is that we operate in silos. The left hand very often doesn't know or wish to know what the right hand is doing. And in order to build a robust economic system and to deal with evolving financial crime, among which things this bill is seeking to address, we have to operate our system in concert. So I reassure Senator Mark that we will be coming with more amendments, not to plug loopholes by way of a deficiency in our governance mechanisms and our governance strategies, but as an evolving process of improving the society for the fabric and citizens of this country. Mr. President, as expressed here today and in the other place, that global facility is a body which is responsible for supporting countries in adopting enhanced mechanisms in measures to increase their compliance with the international AML CFT framework, and is a unit of the European Commission. And I thank Mr. Peter Cavendish, Ambassador Peter Cavendish, for being the moving force in assisting in the workshop that is taking place right now. We are working with our international partners as we build our resilience. And that global facility is assisting the Registrar General's Department now and other relevant state agencies as they prepare for the visit of the peer review team. In furtherance of this, there was, I am pleased to announce, a very well-received training session hosted very recently under the auspices of my ministry in collaboration with the global facility, informing our stakeholders, those very stakeholders that I was speaking with yesterday at the Hyatt, of the legislative changes being brought to the fore today by this bill. And I should also observe, Mr. President, that in light of the ongoing assessment, the Office of the Registrar General has embarked on a program of striking off companies for failure to file critical post-incorporation documents, in particular, annual returns for a period of 3 or more years. The Registrar General has identified at March 31st, 2024, some 63,000 companies, ostensibly inactive companies, and recently commenced a comprehensive striking off process with respect to these entities. And I say ostensibly inactive because this is an indicator of whether or not a company is carrying on business or is in operation, and whether or not it is filing its post-incorporation documents regularly or at all. Naturally, of course, that omission is often largely due to inadvertence or neglect. Moreover, Mr. President, this exercise serves to highlight that the old back-of-the-envelope approach to corporate administration must end. Both the FATF and the Global Forum frown on dead corporate entities reposing in registries, so that the removal of inactive companies shall go a long way in demonstrating our commitment to becoming more in compliance with the requirements of these intergovernmental and international aid bodies. Incidentally, Mr. President, Act Number 4 of 2024 has removed the previous requirement that Registrar General publish notice of intention to strike off companies in the daily newspapers. The obligation to publish in the Gazette continues, but the Registrar now has a discretion to decide what other means of publication of such notices may be used, and has begun publishing such notices. And I say this to the listening public: such notices are being published on the official website of the company's registry. So look there, not necessarily in the Gazette or not necessarily in the daily newspapers. The requirement to publish in the daily newspapers was, as one can certainly imagine, beset with logistic and financial challenges, not to mention delays. All part of the evolving process of improving our financial regulatory system. Mr. President, with respect to the present bill, a key amendment has been made to the procedure by which a company goes about obtaining beneficial ownership information. Honourable Minister of Finance spoke to that at length. As mentioned by the Honourable Minister, this amendment is in Clause 18 of the bill, which amends Act No. 4 of 2024. I shall now expand on the new regime pertaining to companies and to external companies. All such companies must now obtain and ascertain beneficial ownership information in the manner that they consider appropriate, mindful of the overarching legal obligations to verify the currency and correctness of such information. The circuitous former procedure by which the company would send out notices to its shareholders and putative beneficial owners, calling on them to respond to the company with information, is being abolished by this amendment, which recognizes that corporate structures are not necessarily one size fits all. Furthermore, as the concept of beneficial owner has now evolved to consider ownership and control of a company as a whole, moving away from ownership of a particular share, so too must the process to ascertain and obtain such information evolve. These new procedures accord with international best practice and are more likely to result in the elicitation of more accurate beneficial ownership information, not to mention a drastic reduction in the administrative burdens often encountered in the current regime. Further, the beneficial ownership information disclosure requirements are extended to trusts and legal arrangements and firms and partnerships, a matter also spoken to by the Honourable Minister of Finance. The bill specifically, Mr. President, applies to express trusts as opposed to implied trusts, which are not always readily discernible. Further amendments were introduced, setting out a requirement for such trusts and other legal arrangements to now register with the Registrar General pursuant to the Trustees' Ordinance. This requirement that trusts be registered is an acknowledgement of the mischief for which they can be misused in terms of facilitating financial crime and tax evasion. And in any event, it would be pointless to mandate the Registrar General to monitor beneficial ownership information disclosures and the verification of such without trust being within his purview. Indeed, Mr. President, the bill exemplifies how the Office of the Registrar General has transitioned from being a mere repository of information into a more dynamic, active, functioning department. The Registrar General is now not only required to maintain her own registers of beneficial ownership information with respect to various legislation, but must also verify the currency and accuracy of the registers maintained by the companies, firms, and trusts. And accordingly, the bill now endows the registrar with power to require the production of documents, accounts, etc., pertaining to beneficial ownership information, the ability to visit relevant premises, to conduct on-site examinations and inspections, as well as to suspend and even cancel registrations of various entities, not to mention the ability to impose disabilities upon the power, for example, of trustees to exercise their functions pending non-compliance with relevant laws. These powers are dispersed across the Registrar General's legislative components in this bill. Might I add, Mr. President, that this activist role conforms to international best practice, is what is expected of us by our regional and global partners, as well as corporate registers internationally, are called upon to assume the mantle of monitoring and oversight obligations. As I have just said, a back-of-the-envelope approach just cannot continue. We are very optimistic, Mr. President, that good progress is being made by the passage of this bill into law, and I urge all members of the Senate to support this bill for its passage successfully into law. And with that, I thank you, Mr. President.